developed and supplied lethal technologies and autonomous weapons to the Ken Niboye government, without which the unlawful assignment of Uzuri residents to their residencies, the death of myriad number of civilians, medical staff, and patients, as well as the destruction of churches and sanitariums in Uzuri would not have occurred. Your Honors, this act constitutes grave violation of international humanitarian laws. It is in light of this fact that the prosecution seeks to confirm charges of war crimes against Ms. Lushomo
Counsel,
Ngala.
if I may interrupt you for a moment, can you define the word grave? How do you interpret this word grave?
Your Honors, for a case to be entertained by this court, it must be grave in nature. By grave, it means that it must be serious. And to measure the seriousness of a crime, the means employed in committing it and its impact on the civilians and as well as the victims of the crime are taken into consideration. If I may proceed, Your Honors, the act of the defendant herein constitutes grave violation of international humanitarian laws. In light of this fact, the prosecution will address the three substantive issues for determination laid down before this honorable court. I will speak on the first issue, while my co-counsel will address this court on the second and third issues, respectively. Your Honors, I will proceed to make my submission on the first issue. The first issue is whether the case against Ms. Lushomo Ngala is admissible before the AFCJHR. Your Honors, the prosecution will address this issue from two standpoints. Firstly, the jurisdiction of this court, and secondly, the admissibility of this case before this honorable court. On the first standpoint, which is the jurisdiction of this court, the prosecution submits that in line with Article 3 of the Malabo Protocol, this court has international criminal jurisdiction to entertain this case. The prosecution further submits that all four preconditions necessary for this court to exercise jurisdiction are satisfied in the circumstance of this case. Firstly, the subject matter of this case, which is war crimes, as can be gleaned from paragraph 30 of the Statement of Agreed Fact, falls within the crimes listed in Article 28A of the Malabo Protocol, thereby conferring jurisdiction rationale materiel on this court over this matter. Secondly, the crime with which the defendant is charged were committed after the entry into force of Malabo Protocol. For clarity, Your Honors, it can be gleaned from paragraph 31 of the Statement of Agreed Fact. I can't hear you. I can't hear you, my lord. I can't hear you.
I think you can proceed. You can proceed.
Okay. Your Honors, secondly, the crimes with which the defendant is charged were committed after the entry into force of the Malabo Protocol, as envisaged by Article 46E of the Malabo Protocol. For clarity, Your Honors, it can be gleaned from Article 31 of the paragraph 31 of the Statement of Agreed Fact that the Malabo Protocol entered into force in 2019. Furthermore, a community reading of paragraph 15, paragraph 21, and paragraph 26 of the Statement of Agreed Fact discloses that all the crimes charged herein were committed in 2022. Hence, this court has jurisdiction rationale temporis over this matter. Thirdly, Your Honors, the prosecution notes that Article 46 EBs of the Malabo Protocol sets out four conditions, satisfaction of one of which we confer jurisdiction
Counsel,
rationale personnel.
If you can enlighten us about the ratification of this protocol, throw some light on the ratification, please.
Yes, Your Honor. Your Honors, the protocol was ratified by the states which are by the states in conflict herein. The Republic of Salima, as well as the Ken Niboye government, ratified the Malabo Protocol, as can be gleaned from paragraph 31 of the Statement of Agreed Fact. If I may proceed, Your Honor. Turning to the third condition on which this court can exercise jurisdiction, Article 46 EBs of the Malabo Protocol sets out four conditions, satisfaction of one of which we confer jurisdiction rationale personnel over this matter on this court. Your Honors, it can be gleaned from Statement of Agreed Fact that the crimes charged herein were committed on the territory of the Republic of Salima, who is a party to the Malabo Protocol. Hence, this court has jurisdiction rationale personally over this matter. Lastly, Your Honors, Article 46F of the Malabo Protocol envisages that it must be a state party that must submit the crime charge to the prosecutor. In the circumstance of this case, it can be gleaned from paragraph 31 of the Statement of Agreed Fact that the Republic of Salima submitted a request to the prosecutor to institute this action. It is in line with this argument that the prosecution submits that this court has jurisdiction to entertain this case. Turning to the second standpoint of our issue, Your Honors, which is the admissibility of this case. The defense notes that Article 46H, paragraph 2 of the Malabo Protocol sets out 3 conditions which must be satisfied before a case is admissible before this honorable court. Your Honors, we will address all the conditions and show how they are satisfied in the circumstance of this case. On the first condition, which is that the state that has jurisdiction must be unwilling or unable to prosecute or investigate the defendant. Your Honors, in the circumstance of this case, the Republic of Salima has jurisdiction because the crimes were committed on our territory. And it can be gleaned from paragraph 28 of the Statement of Agreed Fact that the Republic of Salima is unable to prosecute.
How do you distinguish between the quantitative and the qualitative number with respect to the gravity which you are pleading before us? Any difference between the qualitative and the quantitative criteria that has to be fulfilled in your argument? You're talking about the admissibility.
Yes, Madam President. I will get to that in my subsequent argument. However, I will address it now. On the issue of gravity raised by Madam President, a case must be of sufficient gravity to justify further action by this court. Your Honors, the ICC held in the prosecutor versus Charles that gravity of the case is assessed from both the quantitative and the qualitative perspective. On the quantitative perspective, Your Honors, it denotes the number of victims of the crime. On the qualitative perspective, the ICT were held in the prosecutor versus Baskage that the means employed in committing the crime should be taken into consideration. Your Honors, addressing the quantitative perspective of gravity in the circumstance of this case, the ICC in the prosecutor versus Abu Garda held that the death of 12 victims as well as the injury caused to 8 satisfy the quantitative threshold of gravity. Your Honors, in the circumstance of this case, it can be gleaned from paragraph 21 that 37 civilians were killed, 41 were also injured, as well as churches and sanitariums which were destroyed by Haddam. On this note, the prosecution submits that the quantitative threshold of gravity is satisfied in the circumstance of this case. Turning to the qualitative threshold of gravity, Your Honors, the means used should be taken into consideration. In the circumstance of this case, Bet Target AI and Adam, which were used to orchestrate the crime charge hearing, are autonomous weapons. Your Honors, it was disclosed as paragraph 18 of the Statement of Agreed Fact that Bet Target AI struggled to identify individuals with threats when it involves group of 50. Your Honors, it was also disclosed at paragraph 28 that Haddam struggled to distinguish between military objectives and civilian objects. Your Honors, these defects in the autonomous weapon make them unpredictable, and the ICRC recommendation on use of autonomous weapon system in warfare rule out autonomous weapons which are unpredictable. Your Honors, the act of the defendant to have supplied the use of unpredictable autonomous weapon in warfare makes the means used to commit the crime indiscriminate. Hence, the prosecution submit that the quantitative threshold of gravity is also satisfied in the circumstance of this case. On the whole, we submit that this case is grave for this court to take further action.
I have a question.
Yes,
why should this court consider the ICC criterion? This is not the ICC. What is the relevance of the developed criterion?
Your Honors, I cited the ICRC recommendation. It is a publicist opinion, and under Article 31 of the Statute Protocol to the African Court of Human Rights and People's Court, it is persuasive to this court, and this court can take notice of it.
Thank you for clarifying.
Turning to the second for this case to be admissible before this honorable court. The state that has jurisdiction, as earlier stated, did not prosecute the accused. Hence, this case is admissible before this honorable court. Also, Article 46H of the Maloro Protocol envisages that the conduct with which the defendant has been charged must not have been tried before any other court. Your Honors, the state that has jurisdiction to try this case is unable to prosecute the accused. Hence, we submit that no court has tried the defendant on this subject matter before this honorable court. On the whole, Your Honors, the prosecution submits that this case is admissible before this honorable court. Yes, Your Honor.
Excuse me again, sorry for the interruption, but which country is the one that has to judge the defendant?
The Republic of Salima can try the defendant because the crime was committed on our territory, Your Honors.
But has he tried to judge her?
Yes, the Republic of Salima investigated the defendant. However, they were unable to prosecute the defendant because the Kingdom of Bukada refused to extradite the defendant to Salima, as contained in paragraph 28 of the Statement of Agreed Fact.
Okay, thank you, Agent.
Yes, Your Honor. Your Honors, on this note, we submit that this court has jurisdiction to entertain this case, and this case is also admissible before this honorable court. Before I defer proceeding to my co-counsel, I want to address this court on the nature of armed conflict. Your Honors, paragraph 4 of the Statement of Agreed Fact discloses that Kendi Boye occupied the territory of Salima. Your Honors, in line with Common Article 2 of the Geneva Conventions, this shows that there is an international armed conflict. There is an international armed conflict in question. Your Honors, on this note, I will defer proceeding to my co-counsel, who will address this court on issue 2 and issue 3 respectively. Thank you, Your Honors.
So prosecution 2 may now start and plead before us. You're not audible. There is some problem with your speaker. You're not audible.
Madam President, she will address the court from my own end. We'll switch. We're in the same place.
Can I be heard?
Yes, you are audible now.
Madam President, Your Honors, may it please the court. As earlier introduced, I am Mustafa Hawa. I continue with the prosecution. In seeking to confirm the charges against Ms. Lushomu Ngala, the prosecution shall establish that the war crimes of unlawful confinement, intentional attacks against plant protected persons, and attacks on protected objects were committed in Missouri, and that Ms. Lushomu Ngala did incur individual criminal responsibility via aiding and abetting. If it pleases Your Honor, the prosecution would like to proceed with their submission. As to the first charge of unlawful confinement, Your Honors,
excuse me again,
the prosecution submit that this war crime.
Yes, but I hope you can enlighten me. I'm not. I didn't understand why there was an armed conflict. What's the nature of the conflict? What are the rules for that conflict?
Again, please, could you come again?
Oh, yeah, sorry. I think that's internet connection. Can you please tell me why is there an armed conflict and which kind of armed conflict?
Your Honor, in response to your question, the prosecution submits that the armed conflict in question is an international armed conflict in view of the military occupation of the Kedibonyi Armed Forces in Uzuri. Your Honor, may I proceed?
Yeah, but how was that occupation? What are the rules for the occupation?
Your Honors, Article 2 of the Fourth Geneva Convention provides for this, Your Honor.
Okay, thank you.
Thank you very much. Madam President, Your Honors, as to the first charge of unlawful confinement, Your Honors, we submit that the war crime was committed in Uzuri based on the following assertions. One, that the confined persons are protected persons and did not engage in hostile activities. Two, that Article 43 of the Fourth Geneva Convention has not been complied with. Your Honor, with respect to the first standpoint, Article 4 of the Fourth Geneva Convention.
Can you let the court know under what article are you pleading that the confinement was found to be unlawful?
Your Honors, in response to your question, Article 4 of the Fourth Geneva Convention provides that protected persons are persons who, in any case, find themselves in the case of an armed conflict. Your Honors, and in Prosecution versus Tadic, 1997, the persons were extended to accommodate both nationals and non-nationals. Now, Your Honor, Article 5 of the Fourth Geneva Convention also provides that protected persons who engage in hostilities are deprived from their protected status. However, it is our contention that these protected persons—
You are saying they were deprived. Do you think the deprivation was arbitrary?
Madam President, we submit that the deprivation was an arbitrary one in nature. May I proceed?
Please,
I have a question.
Yeah.
So wouldn't you agree that it is that there were civilians that were actually participating in the conflict, and wouldn't you agree that that it is the power of the government to decide whether to confine these people and how to deal with these kind of participants? Like, where would you draw the line? Agent, I have a question. Yeah.
Your Honor, in response to your questions, we do not agree that these persons engaged in hostile activities. And we also submit that the Kedibonyi government did not have the power to confine them with respect in view of their protected status. Your Honor, in answering your first question, we would refer to the ICRC interpretive guidance on direct participation in hostilities, which provides for 3 cumulative conditions on conduct that amounts to direct participation in hostilities. Your Honors, these 3 conditions are as follows. 1, the act must reach the required threshold of harm. 2, there must be a direct causation between the act and the likely harm. 3, there must be in existence a belligerent nexus. Your Honor, with respect to the first condition, we submit that there is no evidence of the civilians' action adversely affecting military operations, as all that took place was merely political demonstrations and expressing of support for the ULF via the use of Asadat. Your Honors, with respect to the second and third condition, we also observe that there is no evidence showing a direct causation between the act and the likely harm in view of the reason given. Your Honors, with respect to the third condition of the existence of a belligerent nexus, now we do understand that the civilians who were confined unlawfully did express their support for the ULF. However, this is not to be construed as an umbrella term for the existence of a belligerent nexus. Your Honors, all that took place was a manifestation of their freedom of expression as provided by Article 19 of the ICCPR. May I proceed, Your Honor?
Sorry, Jen, what's the source of law for participation in hostilities? And what's the difference between active participation and indirect participation?
Your Honors, please, I did not get that right.
What's your source of law for participation in hostilities? And what's the difference between active participation and direct participation and indirect participation?
Your Honors, the ICRC interpretive guide cited and relied upon by the prosecution constitutes publicist
Okay.
opinion
Do you
in
have
view of
any
Article
other?
31.
Okay. Do you have a case of an international court, for example, that establishes participation in hostilities?
Your Honors, we would like to refer to the case of the prosecution versus Tadic 1997 for this, Your Honor.
And
Your
what
Honors,
does it state, the case?
Your Honors,
Yes.
I did not get what you said, Your Honor.
Oh, what's the facts of that case?
Your Honors, in that particular case, the defendant, Tadic, was charged for war crimes, crimes against humanity. Your Honors, in particular, the war crime which is relevant here, the defendant was charged for unlawfully confining the Bosnian Muslims, Your Honor. And that is relevant to the charge at hand. May I proceed to your second? Your Honor, with respect to the second limb of your question, asking about the difference between direct and indirect participation in hostilities, we submit that in cases of direct participation and or active participation in hostilities, in this instance of direct participation in hostilities, the protected status of the persons are revoked. However, indirect participation in hostilities, for example, political demonstrations now, do not lead to the loss of the protected status of these persons. May I proceed, Your Honor? Your Honors, may I proceed?
I think you should. Yes, please.
Moving to the second charge of intentional attacks against planned protected persons. Your Honors, we submit that this war crime was committed in Missouri, the direction of attack at protected persons. 2, that the principle of precaution and proportionality as required by customary IHR rules has not been complied with. Your Honors, with respect to the first limb of my argument, Article 15 of the Additional Protocol 1 provides for the protection of medical personnel. Your Honors, Article 51 of the Additional Protocol 1 also provides for the protection of civilians. And Article 15, sub 5 of the Additional Protocol 1 provides for the protection of religious personnel. Having established the protected status of these persons, the prosecution shall go on to establish that indeed there was a direction of attack at these persons. Particularly at paragraph 21 of the Statement of Agreed Fact, it is revealed to us that bird targeted an attack at civilians, killing 37 of them and leaving 42 others injured. Your Honors, we also observe at paragraph 25 of the Statement of Agreed Fact that St. Elijah's Church was attacked, killing a priest and his 4 acolytes. On the same footing, we observe at paragraph 26 of the Statement of Agreed Fact that Adam, an invention of the defendants, launched an attack at Mountain View Sanatorium, killing patients and medical personnel of an unknown number. Your Honors, we further remind this court that these persons are protected persons. Moving on to the second limb of my argument, that the principle of precaution and proportionality has been grossly violated. Your Honors, Rule 15 of the customary IHR.
If I may interrupt you, can you throw some light about the throwing of stones by the civilians at the armored vehicles? Don't you think that is also a part of active participation?
Your Honors, in response to your question, we submit that the conduct of throwing stones did not amount to a conduct of hostilities. Your Honors, we observe from the Statement of Agreed Fact that the civilians' conduct of throwing stones was simply an act of individual self-defense, as they thought that bird targets directed an attack on them. Your Honors, with further clarifications, bird targets launched an attack at the building which they were in front of, and in an act of self-defense, they retaliated by throwing stones at this, Your Honors. And this did not amount to conduct of hostility, Your Honor. May I proceed? Very well. Your Honors, Rule 15 of the customary IHR rules provides for the principle of precaution, and it is to the effect that civilian casualties are to be limited, as shall be seen subsequently in the course of my argument, assuming but never at all conceding that the protected objects launched with an attack are military objectives. Article 58A of the Additional Protocol 1 requires that civilians and civilians' objects within the parameters of the military objectives are to be evacuated, or adequate warning is to be given of the attack. However, Your Honor, a perusal through the statement of agreed fact would reveal that none of this warning was given to these protected persons. Your Honors, the principle of proportionality in view of Rule 14 of the customary IHR rules is to the effect that the military advantage to be anticipated must supersede the civilian casualties. However, on the same footing, we observe from the statement of agreed fact at paragraph 21 that in order to gun down a possible ULF soldier with an RPG, 37 civilians were killed and 42 others were left injured, hence not complying with the principle of proportionality. And on this note, we submit that the war crime of intentional attacks against planned protected persons took place in Uzuri. Moving to the third charge of attacks on protected object, it is our submission that there was a direction of attack at these protected objects which did not constitute military objectives. Your Honors, Article 28D of the Malabo Protocol and Article 51 of the Additional Protocol 1 provides for the protection of medical buildings and religious units. Your Honors, evidence of these buildings being targeted with an attack can be gleaned at paragraph 25 and paragraph 26 of the statement of agreed fact respectively, which provides that ADOM launched an attack at Mountain View Sanatorium, and it also launched an attack at St. Elijah's Church, which constitutes protected objects. Your Honor, the defense at this point may be tempted to prove to this court that these objects constitute military objectives. Respectfully, we submit that this is not true. Your Honor, what amounts to military objective has been outlined in Article 52 of the Additional Protocol 1, which provides that military objectives are objects if by their nature, purpose, and location offer a military advantage and aid in the neutralization of the belligerent. On this note, the prosecution submits that by the nature of Mountain View Sanatorium and St. Elijah's Church, they are not military objectives as they are purposefully used for offering medical services to the immediate community and also as a place of worship. By the location of St. Elijah's Church, the statement of agreed fact reveals to us that St. Elijah's Church is located north of Uzuri, as against the last known operational center of the ULF, which is north of Jabulani, hence not showing a nexus of any military.
I have a question for you. You were talking about the church, right? What is the controversy behind this? Do you think there is any evidence that indicates that this church is for religious nature or for some other nature?
Your Honor, in response to your question, we refer to the statement of agreed fact where it stated that the St. Elijah's Church was used to conduct the burial of one Major Faustino, hence showing that it is an active place of worship as a burial was conducted therein. May I proceed, Your Honor?
All right, yeah.
Moving on to the purpose.
Sorry, I have a question about that. But don't you think that it can be a military object in regards of the necessity of the attack? I mean, of the military advantage that you can take off by taking down the church that are other leaders and other fighters in that church, in the light of the military necessity and the advantage?
Your Honors, there's no evidence of military necessity as the ULF soldiers that converged in this church did not use it as a cover. They only used it to conduct the burial of a Major Faustino, Your Honor. May I proceed?
Do you have any case in, I don't know, any other court of international criminal law?
Your Honor, in response to your question, we would like to refer to the case of, Your Honor, unfortunately, I may not be able to provide this court with that answer.
Okay, thank you.
However, Your Honor, we submit that the ICRC regulations has provided for the guidelines that the armed forces are expected to follow while carrying out military necessity, which involves the use of principle of precaution, that is ensuring that civilians are evacuated, and this has not been complied with. May I proceed, Your Honor? Moving on to the next limb of my argument on the principle of distinction, Your Honor, we submit that the principle of distinction has not been complied with, as ADOM is revealed to us to have struggled to have identified between objects which are military objectives in nature and non-military objectives. Now, having established the war crime of attacks on protected objects, we shall proceed to proving before this honorable court that Ms. Lushomo Ngala has the prerequisite mental element for the commission of the war crime, and that she did incur individual criminal responsibility. Your Honors, with respect to the first limb of the argument, to establish knowledge and intention, the accused is expected to be aware and conscious of the act, coupled with the decision to have participated in the crime. Now, with respect to the first charge of unlawful confinement, it is our submission that Ms. Lushomo Ngala engaged in extensive discussion with the Kadibonye government on the use of Afro-Opt. Your Honor, she is a developer of the Afro-Opt, and hence she had the prerequisite knowledge that Afro-Opt's nature was such that could be used to confine persons and restrict their movement. Now, moving on to bird targets, we also submit that Ms. Lushomo Ngala was very much aware that bird targets may be overloaded when the range of individuals exceeded 50. However, she handed over the autonomous weapon system to the Kadibonye government. Moving on to ADOM, we also observe that she was within the knowledge that ADOM had a particular defect of distinguishing between military objectives and non-military objectives. However, she threw cautions into the wind, into the air, and still handed over these autonomous weapon system that failed to comply with the internationally agreed limits to the Kadibonye government. Having established the presence of knowledge and intent, the prosecution would go on to establish the individual criminal responsibility of Ms. Lushomo Ngala, their aiding and abetting in view of Article 28N of the Malabo Protocol. Your Honors, in prosecution versus Bemba, 3 conditions have been outlined as the element of aiding and abetting. One of the conditions is that the act must have facilitated the commission of the crime. Your Honors, we submit that Ms. Lushomo's provision of Afro-Opt, bird targets, and ADOM to the Kadibonye government has helped and facilitated in launching the attacks at the protected persons and protected objects, as well as facilitating the unlawful confinement of the protected persons. We also submit based on the second condition, which is that there must be a substantial effect on the commission of the crime. Your Honors, we submit that but for the assistance provided by the defendants, the war crimes could not have been perpetrated. Particularly, the statement of agreed fact reveals to us that
Can you let the court know whether there was any evidence that Ngala exchanged the information with the government on their meeting in 2022? Any evidence that you can bring before the court?
Your Honors, paragraph 22 of the statement of agreed fact reveals that Ms. Lushomo Ngala secretly and willingly provided and informed the Kadibonye government of her AI, which selected targets on its own and solely made the decision to strike devoid of any human-machine interaction. May I proceed, Your Honor?
Yeah.
Moving on to the second condition, Your Honor, we submit that
Then
but for the assistance...
The oralist time is up.
Your Honors, as my time has lapsed, we submit that Ms. Lushomo Ngala is individually criminally responsible for the war crimes committed in Uzuri based on the aforementioned elements. If there are no further questions, that will be the case for the prosecution. May it please the court.
Your time is already up. Yes, I think the time is up for this prosecution team.
Your Honor, we have concluded our case, Your Honor.
Yeah,
May it
all
please
right.
the court.
All right. So if we have no more questions from the prosecution, we may now proceed with the defense team. So the defense speaker number 1, if you may please plead before the court.
Okay, good morning, Your Honors. All members of the court. May I please the court? This is Aframed along with my co-counselor Haila Mariam Yaya for the leading of defense.
You have to be a little more louder, and you're not visible on the screen. I can't see you. If the sister judges can see the defense, please let me know.
No, I cannot see him.
So please adjust your camera and your mic properly.
Can you hear us now?
Yes, defense team, you are visible to us. So now let's proceed and listen to your argument, and then we will let you know whether you are clearly audible or you're not.
Okay, thank you, Your Honor. Good morning.
I hope you're
judges, all
logging in
members
from a single device. You're not using the separate devices.
You are using.
If there are 2 devices, then I am sure there will be an echo and the bench will not be able to hear your clearance. There should be 1 device on.
Can you hear us now?
Better.
Yeah, 1 device. Okay. Okay, thank you. Good morning, judges, all members of the court. May I please the court? This is Afra Ahmed along with my co-counselor Haila Mariam Yaya for the leading of defense for Ms. Lishamona Gala. Our defense will have 3 parts. First, inadmissibility of the case, defense for war crime of unlawful confinement, and my co-counselor will address defense for war crime against war crime against protected person and protected property, as well as individual criminal responsibility of Ms. Lishamona Gala. Before starting with inadmissibility of the case as a the defense counsel admitted that
I think you are going too fast. If I may have consensus with the other judges on the bench, because I am not able to make out how much time you are taking. Number 2, I was not able to understand your first argument.
You submit that 15 minutes for the first oralist for me and 18 minutes for the second oralist.
Okay.
Okay, thank you. Before starting with inadmissibility of the case, the defense counsel accepts that the court has a jurisdiction over the case. But even if the court has a jurisdiction over the case is inadmissible for 2 reasons. First, as per Article 46H sub 1 of Malabo Protocol, the jurisdiction of the court shall be complementary to the national court when the state is unable or unwilling to prosecute the defendant domestically. In the case at hand, the state of Salima issued an arrest warrant and just asked extradition to Salima instead of seeking a recourse from the local court of Bukada. In this case, the mere rejection of Bukada to extradite its own national to Salima doesn't show its inability or unwillingness to prosecute the defendant as per Article 46H sub 3 and sub 4 of Malabo Protocol.
Counsel,
therefore,
I have a question. Okay. So, what would you suggest? What should have been done in order to suffice for the requirements?
Okay, thank you, Your Honor. There has to be an exhaustion of local remedies. First, they have to ask a remedy from the ordinary court of Bukada. After that, if the state is unwilling or unable to prosecute, according to Article 46H sub 3 and sub 4 of Malabo Protocol, they can move to the jurisdiction of this court.
And where do you find the requirement of exhaustion of local remedies in the Malabo Protocol?
In the in the Malabo Protocol, it says that Article 46H(1) of Malabo Protocol, it says that the court have a complementary jurisdiction to the national court of the state. In this case, we can understand that the states have to exhaust local remedies which are found before the jurisdiction of this court.
Thank you.
Can I proceed, Your Honor?
You may.
Okay, thank you, Your Honor. Therefore, the prosecution against Mr. Shomona Gala will be inadmissible since there was no exhaustion of local remedy as per Article 46H(1) of Malabo Protocol. Second, as per Article 46H(2)(d) of Malabo Protocol, the case has to be sufficiently grave in order to justify further action by the court. In the case at hand, the defense counsel submitted that the case has no sufficient gravity in accordance with two dimensions. In Abu Garda case, there are two requirements used, the qualitative and the quantitative requirements to assess the gravity of the case. In the first hand, regarding the quantitative criteria, in the case at hand, according to statement of fact number 21 and 25, the skill of bird target and Adam attack were insufficient to meet the requirements of quantitative criteria, since there was a small number of victims. In Prosecutor versus Mutahara case, which brought us to ICC on the charge of pre-trial chamber 2, it accords 200 days as a quantitative criteria to meet the
defense. If I may pose a question, do you have any evidence on the numbers of deaths and injuries in relation to the war crime of attack? Any evidence on the number? If we are talking about the quantitative and the qualitative criteria.
In the case at hand, there were 37 days and 42 injuries. But in our mentioning case, there has to be 200 days in order to accord the threshold of quantitative criteria.
So, are you discussing the gravity on the basis of the number of deaths that have taken place?
Your Honor, in this case, there are only 37 days, and the priest and 4 acolytes in statement of fact number 21 and 25. However, in the case Prosecutor versus Mutahara, it accords 200 days as to justify the quantitative criteria. So that case has not satisfied the quantitative criteria. Can I proceed, Your Honor?
Yeah, proceed.
Okay, thank you, Your Honor. Regarding the second criteria, the qualitative criteria, with the defense counsel consider the manner of the commission, the impact of the alleged crime, and the defendant's role in the commission of the crime. Regarding the manner of the commission, the means employed by the KD1 government was discriminate and in line with IHA. According to fact numbers 18 and 22, Adam drone and bird target were confined to select military target, and they are not cause deliberate plan to attack the civilian with particular cruelty. Regarding this, rather, Adam software and the bird target software helped or contributed to avoid further casualties in accordance with statement of fact number 19, line 7. Coming to the impact of the alleged act, according to rule number 17 of customary international humanitarian law, the provision of a warfare or a means of warfare which have a nature of causing superfluous injury is or it refers to the impact on the combatant or the victim of the alleged act. In this case, or in the present case, there was no unnecessary suffering caused by the attacks by the softwares, because by the nature of the software and the inputs that constitute them does not cause or cannot cause a superfluous or unnecessary suffering or injury. Moreover, regarding the defendant's role in the commission of the alleged act, according to according to commentary of ICRC 2016, it said that it should be the operator who deployed in the activation stage should take the responsibility for
defense. I would like to interrupt you for a moment and would like you to relate the principle of pacta sunt servanda. You know that principle. Can you just relate that principle in the arguments that you are putting before us?
Okay, thank you, Your Honor. First, pacta sunt servanda is anyone is bounded to the to the things that are ratified or signed by it. Regarding this principle, all of the states who ratified a protocol or a treaty are bounded by the obligations that are stipulated in the protocol. In this case, all of the states have ratified all of the state of Salima and Kediboni have ratified the Malabo Protocol. However, the state of Kediboni doesn't ratify Malabo Protocol. Therefore, all of the alleged acts and war crimes depend on Malabo Protocol. So all of them have to be bounded by the obligations on the Malabo Protocol. Can I proceed, Your Honor?
Okay, you may, yeah.
Okay, thank you, Your Honor. Regarding the defendant's role of the defendant's role in the commission of the war crime, according to commentary of ICRC 2016, it should be the operator who deployed the software in the activation stage should be liable. However, in the case at hand, Ms. Bishomo Ligala was only involved in the development of technology, but she didn't participate on the activation stage of the softwares. Coming to the nature of the armed conflict, the opposing
Excuse me,
country-
agent. Before you continue,
Okay.
don't you think that even if she didn't activate the weapon, she provided the weapon, she created the weapon? So don't you think that that is for a sufficient gravity for us to meet the case?
Okay, Your Honor. Here, Ms. Bishomo Nagala only developed and provided those technology without the intention to commit the crimes of the alleged act. Here, Ms. Bishomo Nagala provided and developed technologies that distinguish civilian from combatant and civilian objectives from military objectives. She didn't have the mens rea or the intention to commit all of the alleged acts in the war, in the armed conflict between UALF and KD-1 armed government.
Okay, thank you, agent.
Can I proceed, Your Honor? Okay, thank you. Regarding the nature of the armed conflict, the opposing counsel submitted that the conflict between UALF and KD-1 armed force is characterized as non-international armed conflict. However, the defense counsel position regarding the characterization is that the conflict between UALF and KD-1 armed force is non-international armed conflict for two reasons. First, according to Common Article 3 of Geneva Conventions, conflict has to occur within one contracting parties to be accorded as non-international armed conflict. In the present case, the conflict occurred within the boundary of KD-Boni. From the very beginning to the ending of the conflict, it was occurred within the KD-Boni territory. According to statement of fact number 1, from the very beginning, Uzuri was enclaved to KD-Boni, and KD-Boni consistently objected its inclusion to state of Salima. Second, the mere support of third state doesn't change the nature of armed conflict from non-international to
defense, you are calling this conflict as a non-international armed conflict, right?
Yes.
Yes. I have a submission. Then what about the military occupation of Uzuri? Since 1974, there was a military occupation going on. And you know that a military occupation constitutes an international armed conflict, even if there is no violence between the states. So how will you counter that argument?
Okay, Your Honor. Regarding the military occupations, from the very beginning, according to statement of fact number 1 and 11, sorry, Your Honor, according to statement of fact number 1, from the very beginning, Uzuri was enclaved with KD-Boni. So there was no military occupation occurred by KD-Boni. From the very beginning, it was a part of KD-Boni, and KD-Boni consistently objected the inclusion of Uzuri with Salima during the decolonization process from Bukada. Therefore, there was no military occupation, rather it was non-international armed conflict occurred between them.
All right, you may proceed.
Can I proceed, Your Honor? Okay, thank you. Regarding the second requirement, the mere support of third states doesn't change the nature of the armed conflict from non-international armed conflict to international armed conflict. in prosecutor versus
me.
Sadiq case, which brought to
Agent, before you continue,
okay, Your Honor.
you're stating that it's an a non-international armed conflict, but can you tell us what's the difference in the rules and the applicability of law if there is an international armed conflict or a non-international armed conflict? How does your case differ in the definition of the armed conflict?
Okay, thank you, Your Honor. Regarding armed conflict, the first one is international armed conflict, which is occurring with which is a declared war or occurring with other state party, or it can be a military occupation, or according to Article 1 sub 4 of Article 1 sub 4 of Additional Protocol 1, it can be a national liberation wars against Russia, a racist regime, military occupation, and colonial domination. However, non-international armed conflict, as according to Common Article 3, it is a non-international character which have occurred within the territory of one state contracting parties, and it has to fulfill, or the conflicting party have to fulfill requirements like responsible command, they have to effective territorial control, and other requirements in the rules applicable to this armed conflict. The four Geneva Convention and Additional Protocol 1 will be applicable to international armed conflict, and Common Article 3 of Geneva Convention and Additional Protocol 2 will be applicable to non-international armed conflicts. So there is a difference between this. However, they have a similarity since there are customary rules that govern both of armed conflicts. Can I proceed, Your Honor? Okay, thank you. Regarding the defense for war crime of unlawful confinement, according to 28D of Malabo Protocol, it can be understood that at first place, in order to say there is a war crime, there has to be a war first, or an armed conflict first. In the case at hand, there was a lot of civilians detained for supporting ULF or involving in protests. However, this confinement on April and May 2022 doesn't constitute a war crime because it was occurred at the time of internal disturbance which are not governed by IHA, because the non-internal armed conflict between ULF and Kediboni armed force started on July 2, 2022. Before that, there was a mere internal disturbance which are not governed by IHA. Alternatively, even if there was an armed conflict at the time of their confinement, there was no a war crime of unlawful confinement for two reasons. According to Geneva Convention for Article 42 and 43, first, there has to be a reasonable ground in order to justify confinement of civilians. In this case, civilians were confined because they are a real threat for the security of the state.
Yeah, defense first speaker, if you can sum up your arguments in 30 seconds.
Okay. For reasonable ground. However, in the case at hand, they are a real threat for the security of the state since they are involving in protest and supporting ULF within a large amount. Second, the confinement has to be in line with procedural safeguards. This means the decision has to be reconsidered by appropriate court. In the case at hand, as we can understand from statement of fact number 15, there was impartial courts to review, and they can also appeal to administrative court of appeal regarding the decision. In the same fact, their confinement was considered within 3 months, which is in line with the procedural safeguards.
Time up.
Therefore,
yeah, we can now move to the defense speaker too. If the other judges have any questions, we are open. Otherwise, we can proceed.
Okay. Your Honors, Madam President, may it please the court, this is Haile Mariam Yayo, representing the respondent. Next to my co-controller Afra, I will continue to submit our further defense on war crimes on protected persons and property, as well as defense for the individual criminal responsibility of Mr. Monigala. Turning to our first submission, we have heard from the prosecution that there was war crime committed against civilian populations. However, that's not the case, and the defense counsel submitted that no war crime against civilian population has committed for the following three reasons. Firstly, no intentional attack was directed against civilian populations. Your Honor, as clearly provided
if you are making such statements, you have to support your statements with some judicial precedents or with some sources of international law.
Okay, Your Honor. According to Article 28D sub E sub 1 of the Malabo Protocol, it clearly requires an element of intention to render an act as a war crime. But in the case at hand, there is no any element of intention to render an act as a war crime. For this purpose, we can refer from paragraph 25 of the agreed fact, which shows that the unfortunate death of civilians was not intentionally directed against them, but it was directed against the church, and the death of the civilians was incidental and collateral. Therefore, the prosecution has failed to establish the intentional nature of the attack against civilian populations. Secondly, civilians were lost their protection during the attack. Your Honor, as clearly provided under Rule Number 6 of Customary International Humanitarian Law and Article 13, Sub-Article 3 of Additional Protocol 2, civilians will be lost their protection if they directly participate in hostilities. And in the case at hand, as you can refer from paragraph 21 of the agreed fact, civilians were direct part in hostilities by blocking the road and throwing a stone on Lieutenant Colonel Kamuzongo, and also impede the military operations of the Kilboni military force, which makes lost their protection during the attack.
I'm sorry, defense. Where do you draw the line? When does a civilian, like how many stones has a civilian, like how many stones do they have to throw in order to lose their protected status?
Apologize, Your Honor. Could you a little bit brief your question?
Yes. I asked, where do you draw the line when a civilian loses their protection? How many stones do they have to throw? It seems kind of arbitrary.
Thank you, Your Honor. In accordance with ICRC Interpretive Guide 2009, there needs to be fulfillment of three requirements to lose civilians' protection because of their direct participation in the conflict. The first element is there should be a threshold of harm. Secondly, there should be direct causation, and third, there should be Belgrade nexus. In the case at hand, both three requirements has fulfilled and the civilians has lost their protection because the civilians were participate in direct part in hostilities with the intention to harm the Kilboni military force and support the ULF. Therefore, it makes.
I'm sorry, defense. What would you answer? Because the prosecution claims that they were merely acting in self-defense. What do you answer to that submission?
Thank you, Your Honor. As clearly provided under paragraph 21 of the agreed fact, there was no any unlawful attack against the civilians which pushes them to defend themselves. Rather, the Kilboni military force was trying to negotiate peacefully to leave from that area, but the civilians were through stone and harm and caused threshold of harm against the little Colonel Kamuzongo, which makes them lose their protection. Can I proceed, Your Honor?
You may.
Thirdly, the attack was proportional. Your Honors, as you can refer from rule number 14 of Customary International Humanitarian Law, as long as the attack was proportional compared to the military advantage, civilian casualties are tolerated.
Defense, can you just give us an example where you feel that what is the objective of this attack? What is the object? Is it attack to some specified categories, or do you think the attack has some military objectives? Or do you disagree with both?
Your Honor, I'm not hearing you.
Yes?
Could you brief your question?
I'm saying that you will argue that to establish the war crime, the perpetrator has directed an attack. Can you let the court know the purpose or the object of this attack?
Your Honor, as clearly provided under Article 13 of Additional Protocol 2, civilians would lose their protection if they directly participate in hostilities. And in the case at hand, they fulfill the three requirements stipulated by ICRC commentary. And it is the position of the Defense Council that the civilians has participated directly in hostilities and they lost their protection during the attack. Can I proceed, Your Honor?
Continue. Yeah, you may continue.
Thank you, Your Honor. Next, the Defense Council submitted that no war crime against religion and medical persons has committed for the following two reasons. First, the attack was not intentional. Your Honor, as clearly provided under Article 28D sub-E sub-3 of the Malabo Protocol, the attack must be intentional to establish a war crime under this provision. Your Honor, as we can refer from paragraph 26 of the agreed fact, the attack was not intentionally directed against medical staffs. It was rather directed against the sanatorium's main building because this building was identified as a military objective. So it is the Defense Council submitted that the attack was not intentionally directed against the medical staffs, and it cannot constitute war crime since the element of intention is not established. Moreover, Your Honor, as you can refer from paragraph 25 of the agreed fact, the attack which caused...
I'm sorry, you're talking us about the medical building, right?
Yes, Your Honor.
What's the nature of that medical building? Is a military object? Is a civilian object? And does it have a special protection for being a medical building?
Thank you, Your Honor. Here, I am presenting that there was no intentional attack against medical staffs, which was a medical persons, because the attack was not intentionally directed against the medical persons. Rather, it was directed against the hospitals, which was identified as a military objective. So that the prosecution.
But isn't there a rule of isn't there a rule of international humanitarian law that medical buildings are protected?
Medical persons are protected under Article 28D sub-E sub-3 of the Malabo Protocol, Your Honor.
But how can you use the distinction, the principle of distinction, if in that building you have medical personnel and also you have injuries? And aren't they like protected persons?
Thank you, Your Honor. Alternatively, the Defense Council submitted that the attack was proportional, even if under customary international humanitarian rule number 14, the attack which caused casualties on protected persons are tolerated as long as it is not excessive compared to the military advantage. And in the case at hand, the Kidboni military force has an excessive military advantage compared to its causes on protected medical persons. So the Defense Council submitted that the attack was proportional compared to the military advantage and no war crime is committed against medical persons. Can I proceed, Your Honor? Thank you, Your Honor.
Yes.
Next, the Defense Council submitted that no war crime against protected property has been committed in Uzuri for the following three reasons. Firstly, the protected properties were lost their protection during the attack. Your Honor, as clearly provided under Rule number 8 of Customary International Humanitarian Law, civilian object will be converted to military objective if by its purpose, location, or use give definite military advantage. In the case at hand, as you can refer from paragraph 25 and 26 of the agreed fact, both the sanatorium's main building, which was originally a civilian object, was converted to a military objective. because of the military activities which has been done in this building. For this purpose, as we can refer from paragraph 26 of the given fact, there was a data collected by Atom Software regarding activities which has been done in this building. It is because after this data process, the building was identified as a military objective, so that it lost its protection during the attack. Moreover, Your Honor, the church has been identified as a military objective and lost its protection because the ULF fighters were frequently meet on this church, and the ULFs together with their flag were located and displayed in this church. It's because of this fact that Dome Software identified the church as a military target and it lost its protection. For this purpose, we can see the case between prosecution versus Pavel Strugar, which decided that the building can lose their protection if the building identified as a military objective. So the defense counsel submitted that no war crime is committed against protected property in Uzuri. Lastly, the defense counsel submitted that—
I have a very simple question. Can you just illustrate what is the role of the liability which is required to contribute to an offense making it criminal? So what is the role in the present case of the word liability?
Thank you, Your Honor. In accordance with Article 46 of the Malabo Protocol, liability can be established in command responsibility or individual criminal responsibility. In the case at hand, the defense counsel submitted that Ms. Luchomo Negala is not individually criminally responsible for war crime committed in Uzuri, because to make individually criminally responsible, there needs to be an element of menzira or intention, which needs to be exist during the commission of the alleged crime. In the case at hand, there is no solid evidence.
You are trying to tell the court that the accused is not liable for any sort of aiding or abetting? That is what you're trying to tell us?
Yes, Your Honor. Ms. Luchomo Negala is not individually criminally responsible in the form of as aiding or assisting the commission of war crime, because to make liable under this provision, especially in the case between prosecution versus Pavel Strugar, which brought before ICTY, it decided that there needs to be an element of intention.
Defense, are you trying to again tell us that that merely providing the means to commit a crime is not sufficient? I mean, how will you read the actus reus in this case?
Thank you, Your Honor. To make liable under the form of aiding or assisting the commission of war crime, there needs to be fulfillment of two requirements. First, the objective element, and second, the mental element. The two requirements are cumulatively fulfilled. But in the case at hand, the defendant, Ms. Luchomo Negala, was only provided the softwares, and she has no unintention and menzira when she provide and supply such technologies to involve and engage or support the commission of war crime in Uzuri, because for this purpose, we can have a look at during the meeting between Kedboni government and Ms. Luchomo Negala, the purpose of approach program was not mentioned during the meeting, which shows that the defendant, Ms. Luchomo Negala, has no knowledge about the purpose of the approach program. Moreover, Your Honor, as we can refer from paragraph 27, line 3 of the agreed fact, Ms. Luchomo Negala, while Ms. Luchomo Negala has now the problem of Atom Software, she has tried her best to avoid the possibility of the commission of war crime by ordering the engineers to solve the problems. This shows that the defendant had no knowledge and intention to support the commission of war crime in Uzuri, and it is during the activation stage, which has been made by the operators of the Kidmori military force, which the alleged crime in Uzuri has committed, not by providing such technologies. Can I proceed, Your Honor?
All right.
Thank you, Your Honor. Based on the above rules and evidences, the defense counsel submitted and respectfully requests this honorable court to dismiss the case presented before the court as the case is inadmissible. Two, to declare that war crime against property and persons has not committed in Uzuri, and Thirdly, to declare that Ms. Lushomo Negala is not individually criminally responsible under Article 46B7 of the Malabo Protocol. Thank you, Your Honor.
All right. I don't have any other question from the defense team. If the other judges on the bench would like to pose any questions, they are most welcome. Otherwise, I think we are right in time. And then what about the rebuttals and the sub-rebuttals? If the court clerk can guide us, it has to be done now. And then how much time do we reserve for each team?
The prosecution reserved 3 minutes for rebuttal, while the defense reserved 2 minutes for sub-rebuttal.
All right.
If it pleases Your Honor, I will proceed to make this rebuttal for the prosecution. Your Honors, the prosecution have 3 grounds of rebuttal. Firstly, this case is admissible before the Honorable Court. Secondly, crimes of unlawful confinement, attack against protected person were committed in Uzuri. And lastly, Ms. Lushomo Negala is individually criminally responsible for the war crimes charge. On the first link, which is the admissibility of this case, the defense submitted
team
that
is required to turn on their cameras also. I think they should also be visible on the screen.
Yes, Your Honor. The defense submitted that the quantitative threshold of gravity was not satisfied in this case. Your Honor, in the ICIC decision of the prosecutor versus Abu Garda, the death of 12 persons and injury caused to 8 were held to satisfy the quantitative threshold of gravity. In the circumstance of this case, it has been disclosed that paragraph 21 of the statement of agreed fact that 37 civilians were killed and 42 were injured. Your Honors, these figures exceed the number that the ICC held to satisfy quantitative threshold of gravity in Abu Garda's case. In light of this, we submit that the quantitative threshold of gravity is satisfied in the circumstance of this case. Turning to the nature of armed conflict, Your Honors, the prosecution, the defense are oblivious of the fact that, firstly, Uzuri is part of Salima because, as can be gleaned from paragraph 2 of the statement of agreed fact, Uzuri aligns themselves through the plebiscite organized by Kingdom of Bukhara. Thus, military occupation, which has been advanced and in line with Article 2 of the common, and in line with common Article 2 of
Some network issue, I suppose.
Yeah. Your Honors, if I'm audible, I would like to proceed with our rebuttal. Madam President.
I think you've lost some time, and then we need some recapitulation of what you were saying.
I actually paused the time, Madam President. The moment he was disconnected, I posted the time.
Okay, then it's okay. So you can start from where you left. Yes.
Thank you, Your Honor. We submit that this case is an international armed conflict. Firstly, because there was military occupation in the Republic of Salima. Secondly, the Republic of Salima supported the ULA fighters in attacking the Keniboye government. Your Honors, turning to the Commission of Crimes of Unlawful Confinement in Uzuri, Your Honors, the defense submitted that the civilians lost their protected status. Your Honors, however, this is not the case. The civilians never partook in hostilities. And in light of this, the prosecution submitted that the civilians never lost their protected status. Turning to the individual criminal responsibility of Ms. Lushomo Negala, Your Honors, the 11th principle adopted by the Convention on Restriction of Conventional Weapons in Warfare, it retains individual responsibility for autonomous weapon employed in warfare. In the circumstance of this case, the individual responsibility resides with Ms. Lushomo Negala because she developed the autonomous weapons. And in light of this, we submit that Ms. Lushomo Negala is individually criminally responsible for the occurrence of all the war crimes in Uzuri. Your Honors, turning to the attack on protected property, Your Honors, Article 52 of the Fourth Geneva Conventions stipulates that protected property must not be attacked under any circumstances. Furthermore, Article 58 of the Fourth Geneva Convention provides that where a protected property turns out to be providing military advantage, all protected persons in that protected property must be evacuated before an attack can be directed on it. Your Honors, this was not done, as can be gleaned from paragraph 28 of the Statement of Agreed Fact. In light of this, we submit that the war crimes of attack on protected person and attack on protected property were indeed committed in Uzuri. On the whole, the prosecution urged this court to hold that this case is admissible before this honorable court. Secondly, the war crimes of unlawful confinement, attack against protected person, and attack against protected property were committed in Uzuri. And lastly, Ms. Lushomo Ngala is individually criminally responsible for the commission of these war crimes. That will be the rebuttal for the prosecution. Thank you, Madam President.
Yes, the defense. Please unmute yourself. Unmute.
Thank you, Your Honor. The respondent have 3 points on sub-rebuttal. First, the applicant stated that the case is admissible, but the defense counsel submits that the case is inadmissible since it does not fulfill the sufficient gravity in accordance with Article 46 of the Malabo Protocol. So the case is inadmissible since it does not fulfill both qualitative and quantitative requirements. Secondly, war crimes on unlawful confinement and war crime against protected property and the person has not committed in Uzuri since there is no an element of intention which is required by both the Malabo Protocol and the International Criminal Law jurisprudence. As long as the element of intention is not sufficiently established by the prosecution, we cannot establish the war crime. And regarding the individual criminal responsibility of the defendant, Ms. Lushomo Ngala, the defense counsel submits that she is not criminally and individually liable for the following 3 reasons. First, as ICRC commentary provided that for regarding responsibilities and using artificial intelligence in armed conflict, there are 2 stages: activation stage and the production stage. And in the case at hand, that Ms. Lushomo Ngala was involved only in development stage, which provide and programmed such softwares, and she has not involved in the activation stage, which has been made by the operator, which is the Kirboni military force. So the defense counsel submitted that the defendant, Ms. Lushomo Ngala, has not fulfilled the main zera to make her liable. Thank you, Your Honor.
The court is now adjourned. Participants should wait in the courtroom for the judges to go to the deliberation room for them to deliberate.
Yes, sir, your microphone is mute.
So we are back in the court with the teams. Teams can turn on their cameras, and we are going to give you the feedbacks. And with the butterflies in your stomach, just wait for a few more moments because we are going to announce the results also. So the butterflies are there. I can see some fear, some terror. I can see just, yeah, some sort of happiness, maybe a mixed feeling. Yes, where is this first speaker of the prosecution? Mr. Yusuf. All right, so we can see everyone now. So I, being the president, would give the opportunity first to my sister judges on the bench to please give the feedbacks to the teams. And then later on, I will speak and culminate and finally give you what is expected.
Hello, I'm just taking the initiative. My name is Julie de Batis. I'm a law student from Berlin, Germany, and I'm very honored to participate in this exciting moot court and to have witnessed your performance today. I really want to motivate you to stick to mooting. I think it's a really nice experience and it's really beneficial for your future careers, possibly as a lawyer or a judge, possibly. And even though right now you're in the position of pleading and submitting as defense or prosecution, these skills also benefit you, or this experience in the future if you decide to become a judge, for instance. So I participated in Jessup International Moot Court last year, and now I'm in the position of a judge, and I really want to encourage you to keep on mooting and also investing and engaging in other moot court competitions, maybe also from the other side of the bench. So let me move on to some feedback. So I have 5 tips I want to give all of you just to improve your styles in mooting. So first of all, and this is something I saw with all of the participants, and please just understand that as like critique that you can use to improve, okay? So first of all, questions are your friends. I feel like sometimes participants are afraid of questions from the bench, but I think it's a good thing because it shows that the judges understand what you're trying to say, and it's like an opportunity to engage with the bench and to clarify some points. And then the second point, I really want to encourage you to speak slower because that conveys confidence. And sometimes also with like technology and like bad data and stuff, we cannot hear your arguments fully, and that's sad because you only have a limited time, and every second is valuable. Saying that, coming to the third point, I would really encourage you to not always ask whether you can proceed after answering a question, because the judges might take notes and they might be distracted for a second, and just the process of like unmuting yourself and saying, yes, you may move on, and then muting yourself again, it just takes up a lot of time. So I don't know, in a polite way, just carry on your speech in a natural way. And then also a fourth point, whenever you introduce a source of international law, I'd really encourage you to back it up and tell the court why it should take advantage or why it should assess and take into account this source. It's really like you're opening yourself to difficult questions of like general international law if you don't give that information immediately. And then the fifth point, time management is so important. This bench, I think, was pretty nice with time. Like we gave you, I think, sometimes 30 seconds extra, and you should really take advantage of that benefit and really come to the point, like conclude in 2 sentences or 3 sentences the most. Because this is the last impression you leave with the bench, and it's really important to not leave it unfinished. So these are just 5 things I wanted to tell all of you. The prosecution, I feel like both of you were maybe reading from a text, and I was missing eye contact. And I know it's hard with the camera and Zoom to really convey like, you know, eye contact, but a tip that was given to me oftentimes is just to stare into the camera, and then you kind of convey that, you know, feeling. And also, when you read from a text, it's harder to react to adapting your speech and submission if you get a lot of questions. So yeah, this is just something I wanted to let both of you know. And then Ms. Mustafa, I also wanted to let you know, you were sometimes pointing your fingers just to like sum up a few points. I think this is not really appropriate for the style of this format. It might be in person, but not on Zoom. I really like your rebuttals, but keep it down to like maybe 3 points. It's just too much in a rebuttal. And then for the defense, I think both of you were very calm and polite, which is always pleasing and nice, but you're the defense team. So for me, I feel like the defense should be a bit more aggressive just in the style, because you are defending an individual in front of this court for war crimes. This is a very serious claim. And yeah, this is just something I want to say, and I would really want to encourage you to maybe look up a bit more into like general principles of international law and like just get a bit stronger in that area. But I really want to thank you again, and sorry for speaking so long. I'm gonna give the floor to my other judges.
I must say that this was the wonderful feedback, and I'm sure the teams must have grasped whatever you were communicating to them. I can't see the smiles now. Where are the smiles gone? The prosecution and the defense, you people are now freezed. I don't know whether the prosecution is able to listen to us. I can't see them moving. If the organization
I think the prosecution are freezed, but the defense are here.
No, yeah, because I don't know whether they are really able to listen to us or there's some problem. Can you raise your hands or unmute?
Yes, Madam President. We had all what
So the cameras are freeze, but they are there in the background.
All right. Thank you.
Yes, we can hear you, Madam President.
Yeah, thank you. Yeah. So the second judge, if you can just give your feedbacks.
Yes. Okay. So first of all, hi to everyone. I think that you can breathe now. It's over for now. Well, this round. And I want to congratulate you all for just being here. I mean, the all hard work that you have to do just to get in here, to speak, to learn all of these new things of international humanitarian law, international criminal law, that in many universities, they don't teach them in regular classes. I mean, for example, in my university, they don't teach them like only international law, but international criminal law, international humanitarian law. You don't get enough of it in your classes. You have to learn it in moot courts. And for example, that's what I did. I'm from Mexico. I'm right now working in the Mexican Supreme Court, and I did several moot courts of international criminal law. Actually, the first moot court in Spanish before the ICC. So I know what are you feeling. I know how you feel right now, all the hard work. And I encourage you to continue doing this. As my fellow judge told you, you have to continue this. I mean, I know that you want. And these moot courts, these kind of exercises opens you many doors. You have no idea right now the doors and all the possibilities that you will have only because you did the moot court. And especially this moot court that has teams from all Africa, which I love, I encourage. And I'm very, very excited to be here because I haven't been in a moot court of African teams, and I really like it. I really love what I see, and I see a lot of potential in you of being tomorrow the agents of change in your countries and your continent. So congratulations to all. Now, a little bit of feedback, and it's going to be for both teams. I think that my fellow judge already say many things that I agree to, well, actually all, but I want to give you another advices. Case law. It is important for you to manage more case law. You have a few cases, but there are more cases that can be of very help for you can be very helpful in your case. For example, I don't know, other international criminal law courts. I'm not going to say I'm not going to specify the cases nor the courts, but you have to use your cases. And the way you use your cases is also important because you have to know the facts and the law in order to apply it to your case. So that is very important. And also you have to go back to your basics, the principles of international law, especially in generally, go back to your basics in international law. And also, you have to know how to use your law. For example, your sources of law, I know that you all have very clear your sources of law, but you have to know how to use them in the jurisdiction that you're pleading. So that's actually a very good advice that I want to give you. And also, while you're pleading, breathe. Like, breathe. You constantly talks very fast, but breathe, calm down, enjoy it. And if you breathe, you will enjoy it, and we could hear you better. So congratulations, and that's it for me. Thank you.
Yeah, first of all, let me thank both my sister judges on the bench for giving us a detailed feedback And since I'm the last one to speak, either I take the opportunity to speak less, be more crisp and concise, so that we declare the results quickly. But being the president of the court, I would have some observations, which are generally not feedbacks, but observations. Teams, you know that moot courts are an essential part of your clinical and experiential aspect of legal education. So that means when you moot, you are doing a blending of the oratory skills and the research proficiency. And I personally feel, you may agree or disagree, if you speak, you can influence. If you can influence, you can bring changes. Yes or no? Yes or no, the teams? Yes or no? If you speak, you can influence. And if you can influence, you can change things. And I'm sure many of you who are taking part in the moot court are doing research. So what is actually research? Yes, if anyone can just quickly let me know, unmute. Any speaker, what is research? Any speaker, unmute. What is research? I mean, you've done a lot of research, so let me know the meaning of the word research. Yes?
Research simply connotes looking for anything that is.
If you don't answer my question, that means it is a clear indication that you were reading your arguments. No, because this question is an impromptu question. Yes?
I said research connotes looking for resources that will help you in any task.
So what I feel is, you are saying looking for resources. That's absolutely right. I feel research is to see what everybody has seen, but to think what nobody else has thought. Just think and I will repeat my statement. Research is to see what everybody has seen, but to think what nobody else has thought. And this is what we expect in a moot court. My feedback to the teams is, both the teams were great, because moot courts are a lucid window that is given to you to behave as if you have really become lawyers and are going to the courts. As far as the teams were concerned, you know that in moot courts, certain things, they play a very important role. My sister judges have already briefed that. So prosecution and defense, you have to be very, very careful when you speak and when your research is being reflected. Whether it is a national moot court or an international moot court, the authorities and relying on the authorities is very important. I mean, you have to quote authorities. You have to cite authorities. International moot courts, that is very, very important, wherein I was feeling that somewhere this part was lacking. When I was hearing both the teams, I was trying to figure out the epicenter. Where is the epicenter? So clarity, yes, was there. Feasibility was there. The approach was pragmatic and harmonious both. But I felt in one team, I will just not name that team, there was some sort of lack of citing of the authorities, and there was some sort of lack of practice between the speakers also. And you know, the court mannerism also plays an important role. You have to be as polite as you can. You know, in India, we say, know your judge first and then know the case. So you must know what is going on in the courtroom. So the research was a little shallow on one side and a little heavier on the other side. There was a blend of oration that was lacking in X team, but the blending of the oration was better in the Y team. All right, so this is some observations that I had. And if I may be allowed to declare the result now, I will just say who the winner is. But we must be able to see the prosecution team. Until and unless we see them, we will not declare the results. So you have to fix your cameras quickly. Or you have to unmute and at least show us your presence. Yes. This is not the time where you switch off your cameras. We are audible to you? Are we audible to you? We are audible to the teams? Because this now the announcement is for the teams. We have already deliberated on the results. Now the defense team has disappeared. I don't know what they are doing. Once the prosecution disappears, now the defense disappears. What is happening?
We are here now, Madam
We want
President.
everybody. Yes.
Well, the defense are here. It's just that their camera is not showing.
So should I then declare the results, sir?
Yes, I think you can go on because they can hear you.
Without even noticing their expressions.
Okay. So the defense, maybe you just close your camera, then open it again.
I think that is essential because this declaration on a Zoom platform is for them.
Yes, because I think it's just it's just a network problem.
So now, without wasting time, with the consensus of the bench and with the consensus of all three of us, it was a deliberated meeting where the organizers of the moot were also with us in the meeting room. So it's not that only the judges were there, it was a transparent discussion, and each one of us has voted in favor of the prosecution. So the prosecution is again free. I don't know with happiness or with fear, that we don't know. So the prosecution from this courtroom is the winner.
Congratulations also from me. And yes, good luck for the future.
Has the prosecution heard the result and also the defense? The organizers have to ensure whether they know who is the winner.
Well, I'm not sure the prosecution. Could you unmute yourself to confirm, and the defense to confirm you had the results?
Yes, we have confirmed the result, Your Honors.
Okay. Prosecution? Prosecution, we can see you, but we cannot hear you.
All right. So
prosecution did not hear.
Oh my God. So they did not hear anything, or they did not hear the results.
Could you confirm that you can hear us now? Well, they are connecting their audio. It seems like they are having. Yes. Can you hear us now?
Yes, we can hear you now.
All right. Okay. So the announcement was that in consensus with everyone, we declare the prosecution as the winner of this courtroom. Oh my God, now the freezing is turning into smiling. All right.
Yeah, congratulations to everyone.
Congratulations.
Okay, thank you so much.
Thank you, Madam President.
Thank you, Madam President.
Thank you, FIS. Looking forward to the semi-final rounds.
Okay, so thank you very much, Madam President. I think the teams now have heard you clearly. So this was a unanimous judgment by the judges. So there's no dissenting judgment. As you know, as per the rules, the winner of the round automatically qualifies for the semifinals. So we'll be able to make confirmation in terms of the schedule for the semifinals once all the teams that are in the quarterfinals finalizes everything. So hand over to the FIS President, Mr. Bukarim Aziz.
Thank you so much, Mr. Swale. This is the closing remarks. We want to thank Madam President, Dr. Batra, all the way from India. Thank you so much, Ma, for the wonderful feedback, for your time. What you've given them today is more than a feedback. It's like a parental advice that you're giving to your children. Thank you so much, Ma. We appreciate that. To George Battles from Germany, thank you so much, Ma, for your time, for your commitment. You've been with us for a very long time. Thank you so much. We appreciate that. And to George Carrillo from Mexico, thank you so much, Ma. We thank you so much for being part of this and for sharing your experience. We appreciate it. To the participants, you've seen the caliber of judges we brought for you from India, from Germany, from Mexico, and these are people who have done it before. They have experience, they have exposure. So as organizers, it's more than moot for us. It's also about networking, it's about learning. So if you find yourself at Amity University in India, you can go to Dr. Batra. If you find yourself in Germany, you can go to Bartels. If you find yourself in Supreme Court of Mexico, you can go to Judge Carrillo. This is a platform where you can network and connect with people. You want to do your master's anywhere abroad. Absolutely. You can meet those people for guidance. You need assistance in terms of research, in terms of experience, in terms of recommendations. These people will be able to provide it for you. And they've told you, if you participate in MOOT, your life will never be the same. Because in terms of research, in terms of writing, in terms of critical thinking, you have everything, unlike your colleagues who never participated in this process. So for the winning team, prosecution, congratulations. For the defense, we also congratulate you. It's just that the bench has been put in a very tight situation to declare a winner. And in every competition, there must always be a winner so that we can conclude the competition. So, but for us, everyone is a winner. And I want you to, practically, adopt the advice that have been given by the bench today. So once again, thank you so much, the bench, for the wonderful time, for sharing your experience, and to
Mr. President,
yes, sir.
Mr. President, before I conclude, I think the president has something to say.
Yeah, I was about to tell the teams, if the defense is able to listen to me, this research should not go waste. Just try to convert your research into a research paper so that you memorize it and keep it as your prized possession throughout your life. You have done a lot of research. Try writing a research paper on the same theme. You will be very happy in the near future if your research paper is published, and then you remember me. And it's an open invitation to all the people on the screen. Mr. Swalia, you can exchange my phone number and my email ID with any of them, and do let us know the email IDs of the sister judges on the bench. We have a lot of virtual programs, so we can be connected through this platform virtually on any other program that we can host. And I will invite each one of you to do visit India and ping me. Wherever I am, I will bring you back to my campus. It's a wonderful campus, a wonderful university, and we are really, really very hospitable. And let me close this session by saying that you all know that winning and losing is a matter of luck and hard work. What really matters is participation. So thank you so much. And I will now rush back to a meeting that is scheduled for me. And then let's meet on some other platform with more smiling faces and more academic discussions. Thank you.
All right, thank you so much, Madam President. So the session is closed. Thank you so much, Mr. Vice President and Director of Logistics and Operation, Mr. Swale, for putting all this together. It has not been easy getting judges, accommodating the participants, answering questions. The organization has been very wonderful, and we thank you. So we'll see you in next round.